listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law. I am Kyla Lee at Acumen Law, and with me, my co-host, Paul Doroshenko.
Happy New Year, Kyla.
Happy New Year. It's been 2 weeks without the podcast because, well, wait, 1 or 2? 1 week without the podcast. Yeah.
Because we don't do it on a holiday day, I think. Was there a holiday day? Yeah, it was Boxing Day.
Christmas. It was Christmas. I'm
On
not
Friday?
No. Oh,
It was Boxing Day.
yeah. It was Boxing Day. You're right.
In any event, still a holiday.
Still a holiday.
2 weeks without the podcast, and now we're back. Looks like you're in your childhood bedroom.
I am. One, I'm sick, so I'm, reluctant to get out of bed if I don't have to. And number 2, my niece and nephew are being babysat by my parents.
So you're at home.
I'm on the island. I'm
Your
picking up
parents'
the
home.
dog from
Yeah.
his Christmas vacation.
Oh, okay.
Mm.
Well, there you go. So you're at home in your bedroom. I'm in the office working, and feels very strange to be working.
It does. It's weird. It
Weird,
doesn't
weird.
feel like a work day, but it is a work day.
Squeeze in one day between holiday and vacation.
Yep. Pretty
Here we
much.
are. Yeah, that's the way it goes. Well, there's driving law news never stops, so I guess we should probably get into that.
Yeah, I mean, I think the first thing we talk about is the big announcement that the Saskatoon Police Service made on just a couple days ago that they're going to be implementing the mandatory alcohol screening.
Yeah, and the funny thing is, people are on the internet, and I made a comment. I commented on, I think maybe maybe you were quoted. Maybe it was just a CBC story on TikTok, and people were like, "No, this is brand new. It's brand new law." I'm like, no, the law has been in effect since December 18th, 2018, and it was in Regina. They started doing it right away, and in Calgary, they started doing it right away. Everybody was pulled over. But in Saskatoon now, they decided to do it right away, and it's interesting because it's you wonder if it's just they've decided to use it as the threat to discourage people.
Mm-hmm.
They might be doing it every time, but it is an issue really of having ASD trained officers and having ASDs in every vehicle to be able to meet that requirement.
Well, I don't know. I'm also a little bit bit suspicious that they wanted to hold off until the constitutionality was resolved. And remember, we talked about a few months ago the Saskatchewan Court of Appeal, first appellate, appeal court, to rule that it was constitutionally valid. And I think with that big stamp of approval, it's a lot easier for the police to pursue it because they know they're not going to be dragged into like this extensive constitutional litigation, these long charter challenges that complicate the trials. They can just do their regular old impaired investigations.
Well, and I know we've talked to many police officers who didn't like it, who didn't think it was appropriate, didn't think it was necessary, felt that from their perspective, it was a charter violation. There's a lot of police officers, like people are really down on police officers for, reasons that I can understand. When you get pulled over, you're pissed off, not necessarily justifiably so. No, I know. But people
always, but 2 times in the last 15 years I've been pulled over.
They're violating my rights. But there's, police officers are smart individuals. A lot of them very well educated. A lot of them have a good idea of the law, and a lot of them have a very strong feelings on their rights. And when their rights are violated, they don't want their rights violated, and they don't want to be out violating other people's rights as a policy. And so I think there's a lot of officers out there who were uncomfortable with it. And you and I know there were officers who were just not doing mandatory demands. They were forming a suspicion and making a demand or not making a demand. And it may be an issue of that. You're right. That the court gave it the rubber stamp of approval. Now, again, I think we've talked about this before. There is a tendency to assume that something that is passed by Parliament is constitutionally valid. That is sort of the ground, the basis you start with before you even open that file on the constitutional challenge of it. and it's never gone to the Supreme Court of Canada, and it's never gone to a court of appeal in any other jurisdiction in this country. And it may be constitutionally valid. And I think the argument against constitutional invalidity was hurt badly by the pandemic, as we've said, because police officers couldn't stick their faces into other people's faces to smell their breath without putting their lives at risk. But, as memory of the pandemic fades, that charter challenge could still maybe come.
I mean, I think that Saskatchewan case is probably bound for the Supreme Court of Canada. I don't know if they applied for leave, but there was one dissenting judge. So
Was there? Oh, okay.
yeah, there could be a course correct on it. Who knows? Maybe the Supreme Court of Canada, they're wacky. They're wacky. They do wacky things.
They do all sorts of crazy things. They change the law all the time. The ground is always shifting. There's the zeitgeist does matter too, strangely.
This Supreme Court is very unpredictable too. You can't.
Totally unpredictable.
Historically, you would be able to identify, especially on rights-based issues, where they would fall. You could usually predict with good certainty the outcome of these cases. And right now, they strike down the mandatory minimum for child porn offenses, causing, uproar and chaos. Meanwhile, they uphold those ridiculous laws around certificates for breathalyzers.
Yeah. Well, I mean, as you and I said, it seemed they didn't know what they were dealing with. They hadn't considered everything fully on that. And so now that's the law and it's not going to get changed. But that very often you could identify a member of the bench who you could say is probably going to go to the back and explain to everybody what this means and why they shouldn't do it or why they should do it. And I don't get that sense that there is right now in the criminal law realm. So, Moldaver, you could expect him to go into the back and say, well, hang on, you guys, think about what the implications of this are for this type of testing or using the certificate in this way when, it doesn't answer all the questions that you would reasonably ask on the four corners of the certificate. You could expect that. But you cannot expect that with the current bench because some people who you would expect to rule on one thing one way don't and just concur with the rest of the bench. And you're like, okay, all right.
I just think Benny Fish,
Yeah.
back in those days,
Yeah,
they would have been
okay.
like, hell no.
Yeah. And going back before that, Tony Lemaire, Borilaskin, you could predict that those people would say, okay, hang on. The charter exists here for a reason. Let's get back to that.
Yeah.
But yeah, it's very hard to predict. I mean, Fish, I think it was the Woods decision out of Manitoba, ASD decision. And he got so much of the explanation wrong, but he got to the right result in the end. He misstated the criminal code and the law, but he got to the right result in the end. Because he understood what the ultimate principles were that were at stake. And, here you are now, you get the sense that sometimes they're not thinking about the principles that are at stake because they don't necessarily know enough about criminal law. There should always be at least one DUI lawyer on the bench.
So why do you think it is then that BC has not gone the route that, Calgary Police, Saskatoon Police now, Regina Police, Prince Edward Island, other places have gone with the automatic mandatory alcohol testing? Why are we not doing it here? Because it's a lot easier for police. You're not launching into a full-fledged impaired investigation like you would be in Saskatchewan. Why are we not doing it?
Yeah, it's a good question. And, you and I have talked about this, but we haven't talked about it in a long time. I mean, you and I used to discuss this every time it was a news story in Alberta, wondering why it's not happening in BC. Again, you've got police officers who look at it and they think that it's not necessarily something that they want to adopt individually, and they do have that discretion there at the roadside. We've got other aspects of it that I see strangely misapplied. Like I see police officers trying to form a suspicion and they go through all of these steps to try and form a suspicion and then they can't form a suspicion of alcohol in the body. And so they've created a new test The new test is, this person has a previous IRP. I can't form a suspicion. There was a complaint about their driving. Therefore, I'm going to make a mandatory demand.
Just make the damn demand.
Yeah. Well, I mean, from my perspective, I look at it and I'm like, this is not charter compliant. This is not charter compliant. Now you've delayed. This is all supposed to happen immediately. You've now decided to. Our forms, the IRP report to superintendent doesn't contemplate it. This is how long has this been law? It's 2026. The law. It's 8 years coming up in December. Will be 8 years that we've had this legal scheme with mandatory demands, and the government has not changed their form. And you and I point out substantive problems with their form, starting with PKS and ANR and the failure to properly indicate whether or not you're swearing or affirming, and right down the line where there's no contemplation of mandatory demands. And there's so often IRPs are issued in accident cases, and they should never have been issued in accident cases. You and I know that. Immediate roadside prohibitions, for anybody who's listening and doesn't know, 90-day driving prohibition issued on the basis of everything that happens at the roadside, either an ASD demand where the person allegedly refuses, or a fail result on an ASD. You end up with 90 days, 30-day vehicle impound. The forms, the intention of the law was that it not be used in accident cases or where a person has a previous drinking driving on their record. But we see it used in accident cases all the time. The lawyer for the government stood in court and told the judge, is it Sigurdsson? Judge Sigurdsson?
Yeah.
Told the judge, my lord, these are never going to be used in cases where there's an accident or the person's got a previous one, because that would make it, we recognize this would not be a provincially within the realm of the provincial government in that case. This is only going to be used in those cases where somebody's just pulled over at a roadblock or pulled over. So they're not designed in order to comply with that misstatement, confusion, never being applied that way. I don't know. I'll give the lawyer the benefit of the doubt that he was not informed properly about it. But in order to stick with that principle, IRPs, the documentation has never been designed to determine time of driving properly in accident cases and other aspects of the accident case, like determining who was operating the motor vehicle, that it was operable, when it was operable. All the timings for those things are not on there. You and I have been bringing that up for years, like since 15 years, and never been addressed on their form. They've never fixed their form.
No, well, why would you?
Well, they're going to, because there's a new ASD coming out. And so they've hung on all of these years waiting for the new ASD so they can change their form, and they will have it on there, I'm sure, when the new ASD comes out. So I think that form, I want to get back to my point I wanted to make. I'm sorry, this is a long roundabout. You can tell by Kyla's facial expressions change if you're watching the video of our podcast, when she thinks I'm talking too long. But because the form doesn't anticipate it, I think that's one of the reasons that police officers don't make mandatory demands in BC. Because they use the form as a guideline, a checklist basically for their investigation, and they're not looking at it as the form anticipates a suspicion demand. And you could take from that the government wants you to do a suspicion demand.
Okay, good point. Very long point, but good point.
I'm sorry, but it required some background explanation, not just for the audience, but for you, to see where I was going with it.
Oh, yes.
Well,
had you said the form doesn't contemplate it, I wouldn't have possibly known what you meant. You underestimate my intellect significantly there, Paul.
So you should know, gentle listeners and viewers, that Kyla regularly mocks me, and it's much harsher than this when it's not recorded. But it is still something that I don't doesn't really harm me. I enjoy it, and it is worthwhile and useful usually.
It's all in good fun. Yeah. Okay, let's move on from Saskatchewan a little further east to Ontario, because I want to talk about a very interesting case about your right to silence.
All right, tell me about it, because I don't know what you're talking about.
This is a guy who, its case is called Hashimi, 2025 ONCJ 673. And Mr. Hashimi is pulled over for a prohibited driving, for failing to yield to a pedestrian at an intersection. And as the officer is investigating him, he comes to discover that Mr. Hashimi is a prohibited driver. And so when he discovers that, he goes up and he asks Mr. Hashimi about having a license, and why he fled from the scene of an earlier traffic stop. There's some back and forth, and then he's arrested and advised of his right to counsel, but he's not advised of his right to remain silent. So he gets arrested, and there's a breach in the sense that he's not given his right, like his information about his reasons for detention immediately, but the bigger issue is the officer never told him he had the right to remain silent. And a lot of people in Canada, I think, really don't, you'll agree with this, understand their right to remain silent.
Yes, there's very few things you are statutorily required to say, um, and everything else is a right to be silent. And it's so funny because people think that like their statutory obligations are actually peer pressure, that they're just being pressured by the police. Like when you have to identify yourself when you're pulled over, for example, and provide your license. A lot of people think, oh, I'm entitled to not provide my license. It's my license. I don't want to say anything. Those are things that are actual statutory compulsions. But everything else, you know, silence. And people don't know.
People also don't think necessarily that when they're chit-chatting, that the
Yeah.
things that they say could be used against them. And this is
Will be used against them generally. That's what I always tell people. And it's true. Like it's not
this
used for you. It's never used for you. Can't be used for you.
So this is what happens to Mr. Hashimi. After he invokes his right to counsel, he's put in the back of the police vehicle. There's one officer who violates his rights by directly asking him a question, that he answers. And then the other officer, the nice officer, good cop, is driving him. Well, not good cop, because he still violated his rights, but, good cop, bad cop situation. He's driving Mr. Hashimi to the police station so that he can go have the opportunity to speak to counsel in private. And as they're driving to the police station, the officer engages him in conversation, basically like idle chit-chat. He wasn't actively attempting to elicit information from him for the purposes of his investigation. He believed he was only making small talk. This was the officer's evidence, and that they were conversational questions, they weren't about the charges, and the only discussions about the charges that they had were questions asked by Mr. Hashimi, and the officer responded to those.
So
And
the
so,
Crown went to submit to put this in, despite the right to counsel invocation and
well, interestingly, the Crown wasn't relying on anything that was said in that conversation for their case. So they acknowledged that they couldn't rely on it. But Mr. Hashimi still argued that there was a violation of his Section 7 right to silence. Ordinarily, we think about the right to silence in your right to counsel context, but he argued it was a violation of his Section 7 right to silence and sought a judicial stay of proceedings on the basis of the violation of that right.
right.
So
How did it go?
well, I wanted to talk a little bit about the law in the Section 7 context on your right to silence, because again, like I said, and like you agreed, people don't really understand the way that your right to silence works. You have this hold-off period after you invoke your right to counsel, but you also have this residual right to silence under Section 7 of the Charter, which is your life, liberty, and security of the person. And so the Supreme Court of Canada in 2007 ruled that in the context of a police investigation where there's a person who's been detained, where the person knows that they're speaking to a person in authority, there's sort of a way to get at the Section 7 issue that overlaps often with the Crown wanting to admit the statements. Voluntariness. So essentially the analysis is the same. Is the statement voluntary? And in a voluntariness voir dire, the Crown has the burden of proving that the statement was made voluntarily. There were no threats or coercions or promises or inducements or anything like that to get someone to speak. But in this case, it was very interesting because the Crown wasn't relying on any of those statements. They didn't lead them. It was all evidence that was led in the voir dire on the defense's behalf.
Okay.
So,
Okay, interesting. Yeah, no, that's interesting.
yeah. And the Crown argued that the right to silence was not triggered, weirdly, despite the fact that the right to silence is in fact triggered upon detention, and this
Yes.
guy was arrested, so clearly,
Yes.
clearly,
Part of your pantheon of legal rights that are supposed to be explained to you.
yes, and that's what the Supreme Court of Canada said in a case called Tessier, that with while a proper caution will not guarantee that statements given thereafter are voluntary, it stands to reason that proving the accused made a free choice to speak to the authorities will be easier for the Crown if a caution is given. Because a suspect is more vulnerable to making involuntary statements than a mere witness or a person not involved in the crime, the presence or absence of a police caution is an important factor in answering the question of voluntariness. Um, and so that's why we have this police caution. You know, I think people think of it like in the US, anything you say can and will be used against you, which I wish they would say here because that's much more clear than you do not have to say anything, but anything you do say may be given in evidence, which is kind of vague.
Well, I mean, everything, the 10A, 10B of the charter, as we've got it written, the ASD demands, the breadth demand, everything is designed by lawyers, and it seems like it's designed to be deliberately vague,
Yeah.
and everything should be revisited.
So if there's no caution, then the Crown has to prove that despite there being no caution, the person still knew they had the right to remain silent. And so this is what the Crown turns to after they say, "Oh no, it was fine. Um, he wasn't. He didn't have the right to silence." And the judge is like, "No." Then the Crown says, "Well, he knew he had the right to silence," which
On what basis?
the judge also addresses and says Mr. Hashimi never testified, but and there was no direct evidence of what he knew or didn't know about his right to remain silent. But he said there was other evidence that strongly supported the finding that he didn't know his right to remain silent and make an informed choice because the officer had first asked him about this why he lied after he'd been arrested and invoked his right to counsel. He hadn't had the opportunity to consult a lawyer, so he never had the opportunity to get legal advice. You could probably infer after someone talks to a lawyer, they probably are aware of their right to remain silent. And the utterances that were made by him were not conducted in an interview type fashion, but were part of a casual dialogue in the police cruiser. And the judge said it is inconceivable that a layperson would automatically understand the implication of talking to police in these circumstances. And then the fact of a detention may cause a person to feel more compelled to make a statement.
There's the pattern there of asking him questions and expecting an answer.
Mhm.
So of
But even
course
when
he's
you
going to
read
feel compelled.
even when you read the charter rights and warnings, if you don't tell somebody the official warning, and they often don't, you ask the questions, right? You're under arrest for impaired operation. Do you understand?
Yeah.
And it does tend to compel an answer.
Yes. Yeah. Again, I think those are tricks. Like I think it's conceived by government lawyers to actually defeat the rights.
The Supreme Court of Canada suggested it was a trick in GKW when they considered the question that police were asking after the official warning. They were asking a question that say, you do not have to say anything. Anything you do say may be given in evidence. Do you want to make a statement?
Yes.
And then people felt like they had to answer it because they'd gotten, it's just like cross-examination, right? You get them in the pattern answering the questions and they just blab away.
No, I mean, if I was, it hasn't happened to me, thankfully, but if I was 10A and 10B and they asked me about, do you understand? I would not respond. I would not respond. My right to silence. Do you want to talk to a lawyer? That might be the one thing that I would indicate, probably by nodding.
Yeah, I would nod only.
Yeah.
Of course, if you're a lawyer and you're arrested and they don't
Well,
you give
certainly
rights,
not. Yeah, I know.
the
Well, that's
case
the
law
problem.
says, yeah, you knew them.
Well,
You knew them anyway.
I think it's probably very different with a different type of lawyer. But yes, you or I would not have that excuse, but
Securities lawyer, maybe, but
doing our best not to commit any offenses.
yeah, can you imagine like us running the trial? We weren't advised of our rights, and they introduce into evidence 400 episodes of this podcast, 1,000 TikToks.
Yes, yes, that would work against us, I'm sure.
Yeah, well, awesome. A wide body of incriminating evidence.
Yeah. Well, oops. That's the way it goes. Well, and your cases that should have gone to the Supreme Court of Canada but didn't video series, which I note once again, you were awarded a C Lobby Award. Year after year, Kyla continues to produce this great video series that is on YouTube. And I'm surprised that you don't post it on TikTok. You really should have that on TikTok. It seems like a TikTokable thing, where she explains a case that has sought leave to the Supreme Court of Canada, usually a case that's got an important legal issue that would matter for the country, and then explains that the case, where it was sought leave, that it was denied leave, and why it should have received leave. And it's a pretty famous video series. And in fact, she once had the former Chief Justice of the Supreme Court of Canada, Beverly McLaughlin, on her video series. So you should, any listener should seek that out and know about it. That's important news that you were once again awarded. It was just announced, I guess, yesterday. Yes.
The 31st, but I was
31st. Oh, okay. Just announced again that you were awarded this award for your hard work. And you've previously been awarded the award for your body of work because you produce so much on TikTok, um, Twitter, X, and everywhere else that YouTube, where we post videos and things like that. You have been probably the most prolific person in this country in the last 10 years explaining the law to people, and I am thankful for that. I wanted to say that. The other thing I wanted to say is that we are shipping our calendars out. Every year we produce calendars. We ship them to police officers, some people in the justice system, the premier, the attorney general, and others. And they are stupid calendars of me and Kyla looking like idiots. And this year we have a QR code for those calendars where people can listen to us singing a song each month, a version of a song that's related to driving.
Yep. The songs won't be posted until the month in the calendar. So you
Yeah.
got ahead, you can't cheat.
Yeah.
I know you're going to flip through the calendar, those of you who are lucky enough to get one. I know you're going to flip through it to look at all the pictures and laugh right away. It's bad luck.
The thing is, it is bad luck to do that. The thing is that we produced this originally as a joke, and we thought it might be a one-off thing that we would never do again.
We did it to troll the police.
We did it to troll the police, yeah, because we sent it to police officers. We know traffic officers, like, we enjoy our dealings with the police, and I know a lot of police officers listen to the podcast, and so there's that. But after that, it sort of took on a life of its own, and people contact us who want it, and other people, sheriffs. We send it to the sheriffs around the province because there's so many sheriffs we deal with who we really like, and all of them, actually. I can't say that there's met a sheriff I haven't liked in the last 20 years. We also
sent it to the office of the chief judge, who has never responded, but also never told us not to keep sending it.
No, and it hasn't come back or anything like that. I mean, they might just go straight to the garbage. I don't know, but I like to think that they've got it there. I understand some of the judicial case managers have had theirs hanging in their offices, I've been told. We sent one today to ICBC Driver Services, where we regularly go to file matters in dispute. And hopefully they keep it in their office, but they will be mailed out coming this week, and the song will be available as soon as they hit the post. So there is that. Now, the last thing I wanted to say is 2026. I'm looking forward to 2026 for various reasons. I've got concerns about it. Generally, the world, everybody's got anxiety. But the interesting thing that I found is that despite the fact that the charter came into effect in 1982, you and I are still developing new charter arguments all the time. And Section 7 has been a fruitful place to find charter remedies. Section 8 has been a fruitful place to find charter remedies. And charter remedies are going to start hitting the courts more with respect to IRPs in the next couple of years, because there are meaningful aspects of investigations that have not been properly explored. And here we see, it's not just us, right? Section 7 has become a bigger thing in the last few years. And so it is still exciting to be a driving lawyer, and it's still exciting to be involved in driving law. And I thank you, Kyla, for coming up with so many great ideas, and the police officers out there for doing their jobs and attempting to do them well, and very often doing them very well, sometimes completely thwarting our ability to defend our clients. And I thank everybody who listens to the podcast and the great feedback we've got from the podcast over the years, from people. And sometimes people have asked us to cover certain topics, and we have. Shout out to all of our listeners.
Yeah, thank you.
Now, we have one more thing that we have to deal with.
And that's
the ridiculous driver of the week.
The first ridiculous driver of 2026. This collection is driving in 2025, but
yes, but was he really driving?
Was he really driving?
Was he really driving? Yeah.
Was he really driving? So this is in Oklahoma. You can find the video on CNN. It's on TikTok. Somebody's following the police cars, following this vehicle, and it's kind of like slowly drifting in its lane. It goes a little over the line and then corrects. It's
goes all the way to the edge of the line.
Yeah,
it corrects and goes all the way to the other edge of the line and corrects. And it's a newer Hyundai or Kia. And it's driving below the speed limit, but still tooling along there. And the police officer follows it for a while and activates his lights and sirens. No response. This is the police officers got out there because of a civilian complaint. And ultimately, the police officer does something that I thought was an extreme overreaction to the circumstance, because it's a fairly slow-moving vehicle. The police officer does a pit maneuver. And most people know what that is. Basically, you get up beside the vehicle with the front bumper of your vehicle. You try and touch the area between the bumper and wheel of the vehicle in front, and turn sideways to cause the vehicle to go sideways and therefore go off the road. Pit maneuvers are quite dangerous, especially at high speeds, because vehicles roll, people die, and of course it causes property damage. But eventually, of course, because of the pit maneuver, this vehicle does come to a stop.
Yes. It's just interesting because well, you go ahead.
Well, what was determined in the end was that the lane departure software in this vehicle was keeping it in the lane the entire time. It would have driven off the road, but for that. The fellow was asleep, just extreme fatigue, and continued to sleep in the vehicle. How it was maintaining its speed, I don't know if it was cruise control or if that was just the idle speed, or if he had his foot part way down on the pedal. I would think the police officer probably could have just got in front of it if that was safe to pass it, and I think it probably was. And just slowed down in the lane, probably that vehicle would have also had the capacity to stop on its own in that circumstance, and might have been able to deal with it that way. But it was only just driving and staying on the road because of the lane departure software. Wild. And the interesting thing is how much new technology has added to safety in vehicles. I mean, this is a ridiculous sleeper of the week, not really driving, just asleep behind the wheel. But lane departure software, people often turn it off because they feel a vibration in their wheel when they go to change lanes without signaling, and they think that there's something wrong with it. People turn off the collision warning that happens in most new vehicles. People turn off their stability control, and when they do, they turn off those wonderful safety features that have saved so many lives. Like there's postulations. People have speculated that lane departure software has already saved thousands and thousands of lives in North America alone, because people fall asleep and it just keeps you in the lane driving down the road. And as I've been driving our Ford Transit van, which has that for our distillery over the course of this last summer, all around the province, I drove and delivered alcohol everywhere. Many, many times it would keep me in the lane. It would alert me that I was on the edge of the lane. Sometimes I could, not see the line, but it would see the line. True safety feature. Our ridiculous driver of the week could have had his life saved by that software, by that functioning in the vehicle. So hardware, I guess it's safety feature.
Yeah. Interesting, though, that you mentioned that the pit maneuver, people have died. That driver could have been dead, right? Like, imagine with that safety features now, you could die at the wheel and your vehicle could just keep going in the lane, down the highway.
Oh, yeah. Yeah, yeah. I was thinking when you said he could have died. I mean, without it, he probably would have driven off the road and could have died. But with it, yeah, you could have a heart attack. You could have
People have
some
strokes and die in the middle of
medical.
a crash, but not
Yeah,
now.
yeah. You're just going to keep going forever.
It's kind of like when airplanes lose cabin pressure and the pilots don't get their masks on fast enough and they just keep flying until they run out of fuel or hit
Yeah,
a
I don't think I think that's been solved with new aircraft. But yeah, they will auto land. This just recently there was a Garmin system that auto landed a plane when a person was in medical distress, and it did the whole thing. All the videos on there. It was the first test of their system for small planes.
Do they
Uh,
use like AI to communicate with air traffic control to get
Yeah.
clearance?
Yeah, it just explained everything to air traffic control, medical emergency, auto land engaged. This is where I'm landing. This is the airplane, told all the information. We'll stop on the air on the runway. And it did everything right to the point of auto landing, and the plane was fine.
If they can do that in planes, they can do that in cars.
Well, I mean, all of these things already exist. Volkswagen now has a system in their vehicles, a safety system where if you fall asleep, it'll pull over.
Well,
It will detect if you've fallen asleep and pull over. And I'm thinking to myself, well, I'm a sleepy person. I'm just buy myself a VW. Yeah, I work late. I'm going to buy myself a new Volkswagen. Let's just pull over. I don't have to worry about it. If I'm driving along and I fall asleep, it's kind of like the iron, if you leave your iron plugged in, it'll automatically shut itself off. It's got a feature in there to turn itself off so it doesn't burn your house down. But what happens now? Nobody thinks about their iron anymore, so they just leave their iron plugged in and forget about it. Once you've got that safety feature, you start to rely on it, and you no longer take your precautions there.
I'm really tired between court appearances. I could just have a brief nap behind the wheels.
Yeah, yeah, just driving along. If I fall asleep, it'll pull over.
Yeah.
Driving back from Surrey to Vancouver at the end of the day, sometimes I'm pretty tired. Won't have a cup of coffee. I'll just start driving. My Volkswagen will pull over. I'm not buying another Volkswagen. I had a Volkswagen, and people were deceived by Volkswagen. Won't be me. I'll wait until it's in a Toyota.
Okay. Well,
That
that's
note.
our podcast. If you have a driving law related issue, you can give us a call at 604-685-8889 or find us online at vancouvercriminallaw.com and tune in next week for another exciting episode of Driving Law.